Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. I am also here to bring a really good topic to you today. So, if you notice that the topic for today is broken promises, relief for workers trapped by an employer. So, yes, this is happening as we speak in this country. And a part of my job is to be able to assist immigrant workers who are in this situation to be able to get the relief that they need to break away from this employer, find freedom, and be able to live their life here in the US. Now, I want to put this into context. When I talk about broken promises, I'm talking about workers who come into the United States with the promise from employers to give them the green card or give them the work permit. And then when they end up coming, right, they end up finding out that the employer never really intended to give them the work permit or give them the green card. And also, it might be not even for promise of papers, but it might be a promise for certain types of a certain type of wage, right? So, say you may have been promised $20 an hour, and you're thinking that's great. Oh my gosh! And so you are very quick to accept the opportunity to earn $20 an hour, and then when you start working for the employer, you find out that the pay is really $10 an hour. So in that case, what the employer did was they induced you. They used that $20 an hour wage as or promise as a way to lure you into the job. And then when you were in there, probably either quit all your jobs or left your country, came here, now you're helpless, now you're dependent on the employer, and you have no choice but to comply with the employer and move forward with working. That happens to immigrants more often than you think. And I want to educate you about the relief that's available in situations like this. Hi, Caroline. Now, this can happen anywhere. It can happen with an employer. It can happen with family members who also try to do this. Sometimes family members say, "Can you come take care of my kids? And then I'll pay you. I'll give you this great salary. I'll help you get your papers." And when you come, you find that you're not being paid for your labor. You're being paid very low. You're being paid late. So that is also adding to the stress, and you cannot leave because you have nowhere to go and they know it. And sometimes the employer or family members take it a step further and they start to threaten. If you leave, gonna call immigration, or they do it indirectly. If you leave, ICE is gonna, they try to pretend as if they're on your side, but they do use scare tactics to keep you compliant and keep you staying in the situation. So in this case, what we do a detailed evaluation to determine what happened, in what way were you forced into the situation, and then once we find this, the broken promises, which we call fraud, so it's really labor trafficking by fraud, we're able to determine that our clients qualify for a T status. And T status allows you to get a 4-year work permit, as well as your ability to then move on to get your green card. And now, keep in mind too, if you have certain violations in your background, like I see a question that mentions the permanent bar, the T status with a waiver can allow you to overcome the permanent bar and still get your green card. So it is a very, very valuable relief. And most times when employers lure an individual to come into the country, or they're already here and they recruit them to work, usually that person doesn't have family members that can help them or file for them. And so this is usually their only option to be able to get relief. Hi there, Ashley. It's nice to see you. All right, so I'm going to go ahead and answer questions. So go ahead and put your questions in the comments. I'm on YouTube, I'm on Facebook, and I'm on TikTok today. So put your questions in the comments, and some of you may have already seen me on Instagram. You're free to keep putting your questions in the comments. I am waiting for my prima facie later from 6 months. Is it normal? I'd say 3 to 6 months is about normal. How many days can a work permit take to come out after the application? So if it was approved, then you're looking at about 2 weeks. But the processing time depends on what kind of application you're submitting. How long does it take to get a work permit through the U visa? About a year and a half to 2 years. Unfortunately, it does take a little while, but my clients are overjoyed. It's really worth it once they get it. And it is a 4 year that they issue. If you have a 2 year green card and you get divorced, when can you apply for citizenship? So if the time passes, so one, if you are applying for a waiver based on mistreatment, so you're applying for a waiver based on mistreatment and you got divorced, you based on the mistreatment, then you can apply for citizenship still within 3 years. And what will happen is they're going to first bring you into an interview, uh, evaluate whether you qualify for the green card, and then jump straight into the citizenship interview if they approve you. If you got divorced and of course you're no longer married and it wasn't based on mistreatment, then you're looking at 5 years. So if you've been waiting for 5 years, even while you're applying for the 10-year green card, you can apply for citizenship, and that tends to nudge immigration into setting the appointment and adjudicating your case early, processing your case early. Here in the US, married to citizen, I-130 approved months ago, I-485 still pending. Is it normal? So it sounds like they may need something from you for the I-485, and that's why it's still pending. How long does it take to USCIS to make a decision after an RFE? N400 been waiting 3 months. So yeah, it can take anywhere from 2 weeks to 4 months to get a decision. How can you figure out if a person is disqualified by permanent bar? So if you entered the country without papers, you were here unlawfully for a year, then you left, and then you returned illegally again, that's a permanent bar. If you also were deported, and usually when you're deported, you're barred for a certain period of time, and then you cross the border again illegally after being deported, that's a permanent bar. What happened if you enter the country illegally but have kids in America? You know, in this case, you would still have to, uh, once you enter the country legally, you're not able to apply for adjustment of status unless you're applying for VAWA. And that would be based on mistreatment by a spouse or a U.S. citizen son or daughter, if your U.S. citizen son or daughter is age 21 or older. Hi there, Alton. Nice to see you. Any advice or suggestions for me after filing an I-130 last week? So it just depends on what your situation is. Keep up on your case. Make sure, usually it's best to give that information before submitting, but right now it would be a waiting game. Just stay on top of it, and your waiting time is really going to depend on who's sponsoring you, and what the processing times are associated with that. Hi there, big boss. My I-130 was approved and certificate has been sent, but 485 hasn't been updated yet. It's been 3 weeks. Yeah, so it might be they need something. So you have to wait. It's a waiting game at this point. Can you apply for status if your husband's deceased? If your husband was a U.S. citizen and of course, you're married to them, you can apply for the you can apply based on your widow status, and that would enable you to still go through the process, get your green card, even without the spouse. I'm so sorry that happened. Is it normal to get two different biometrics? One has IOE and the other has MSC. IOE is probably for one form, and then the MSC is for another form. Yes, sometimes that can happen. I say just go. Yes, they have the got fingerprints the first time. Don't know why they want it the second time. I just tell my clients to get it done with, so that there's no misunderstandings about them showing up for the biometrics. Separated for over 6 years due to abuse, but still legally married. Can I use VAWA? Yes, you can. Absolutely. Give us a call. That's what we do. Um, now, if you have been separated from your spouse for 20 years, but 20 years ago, before you were separated, they mistreated you, abused you, subjected you to extreme cruelty. Could doesn't just have to be physical, could be emotional, verbal, mental, financial. In that case, you can still qualify for VAWA 20 years later. Even if you get divorced, you still have 2 years after the divorce to apply for VAWA. But if you're still legally married but separated, you can still go for this. Now, if you're legally separated, which is similar to divorce, that's another story. If you have deportation, can you still apply for PIP? Yes, you can. Absolutely. Give us a call. Let's hit the ground running. But you can still apply for this. My I-360 has been approved. What's coming next? So they're probably going to ask for your medical, and then they're going to issue that green card as long as everything looks good for your I-485. How long gonna wait for a green card? I-130. So if you're outside of the country, you could be looking at about 2 years. Um, how can I get help of your immigration? Okay, so give us a call. If you go to the link in the profile of the TikTok page, if you go to the description of the video in Facebook and YouTube, you will see the link to schedule your own appointment. We are filling up fast, so make sure you get your place so we can get started, hit the ground running, help you out. So you can do it yourself, or you can call the office and they will also help you to schedule your appointment. Hi, I have a BSc in social work in Jamaica. How could I acquire a work permit? So I would say in this case, you should seek an employer who can sponsor you. I know that I don't do employment placements or anything or any recruiting, but I do know that employers do, like, for example, healthcare facilities, like hospitals, do hire social workers with under the H-1B program, but that would be what you'd have to do. Work permits are only for certain individuals in the U.S. while they're applying for certain benefits. Good night. Suppose a daughter file for her mom and brother coming on mom, they will get 3 receipts. So if the daughter filed for the mom, that's telling me that the daughter is a U.S. citizen who is age 21 or older. In that case, the mom is considered an immediate relative of the U.S. citizen. That means that the son isn't allowed on the same application. It has to be an individual petition for the siblings, and it's going to take um, a longer time for the sibling process, 14 years. The parents process can take anywhere from a year and a half to 2 years, or under a year if they're in the US, but the siblings can take 14 years. Does a visa get approval come at 1 year mark or during the 1 year? Now, keep in mind, I don't control processing times. So when I give you an estimate, it's based on my experience. So it can come before the 1 year mark, it can come after the 1 year mark. Really, it's about 1 year, but I can never guarantee that it's going to be right on the dot. I usually give a range of 6 months to 18 months. And I would say about a year ago, I was seeing approvals coming in within months. So, it could between 6 to 10 months. But as more and more of the applications are going in, I noticed that the processing time is a little longer, about a year. But I couldn't say a year exactly or before a year. It could come before, it could come after. So let's see. He crossed. Is he able to apply for PAP? Yes. So if the spouse came into the country before June 17th, 2024, they've now keep in mind, here's a big um, situation that you have to keep in mind here. A big qualifier. You have to show if you're going to go for this parole in place process, unless your relative is a military member, if you're going based on this being the spouse of a US citizen, you have to show that you've lived in the United States for 10 years during the time continuously on or before June 17, 2024. So that plus you can show that as of June 17, 2024, you are married to a US citizen, you came into the country without permission, then that can qualify you. But that 10-year residence is going to be very important. Can you apply for status even your husband deceased and you're also enter illegally? So in that case, the adjustment of status is going to be a big problem. You'd probably have to look at the I-601 waiver process for that. So it would not allow you to stay here and apply unless you apply for VAWA based on mistreatment by the spouse. Can a spouse with criminal record sponsor a green card when the case is inactive? Yes, a spouse with a criminal record, if they're the U.S. citizen, can still sponsor as long as they don't fall under the Adam Walsh Act that says that if a minor was involved in the offense, they don't qualify. Good night. What if you get married to a US citizen? How long does that case take? I'd say under a year. 4 months of biometrics for T status and no updates left in misery. So yes, it sometimes it can get very quiet, but it's the results are well worth it as long as you submitted a solid application. It's well worth it. My friend came to the US with a green card since 2021. Can he file for citizenship now or next year? He has to wait 5 years, but if he's married to a US citizen, 3 years from the date he became a green card holder. All right. All right, that's gonna be it for me tonight. I have to head out and head home. So thanks everyone for these questions. They're excellent questions. I'm working to get back on here at 12 tomorrow, hopefully around 12:30. But please like, subscribe, follow. So if I am off schedule, but I still come on, like now where it's a little late, you can still join me if you're available as well. All right, I see one more question. I filed AOS based on VAWA, and then I got ARI. Will it affect me? So I'm not sure if ARI sounds like arrested. Um, so it depends on what the offense is. Correct me if I'm wrong there, but um, it depends on what the offense is that it could affect you. Good evening. I'm it It's almost 9 months waiting for approval. Hope to hear soon. Absolutely. I'm with you on that. All right. That's it for me. Have a good night, everyone. Yes, so it depends on what the offense is. I would say definitely get in touch with our office. Once you have an offense on your record, you want to be sure that it's not going to stop you. In cases where it could affect your case, you might need a waiver for the VAWA to submit. But usually you have to go through the case first to see where it goes. It's also helpful to know so that your attorney can help to negotiate, because if your attorney doesn't know or you don't know the immigration consequences of the offense, sometimes if you don't know, you plead guilty to something that's definitely going to be devastating. But once you are able to talk to us, for example, we're able to evaluate the circumstances. We can advise you how it's going to affect you, and then your attorney can use that to see if they can negotiate, maybe bring the charges down, negotiate a plea deal that will not affect your immigration status. So important at this point that you definitely make sure you get legal advice to figure out how it's going to affect you. All right. Thanks, everyone. Have a good night.